My name is Kirky Webster Sr. I am a retired lead geospatial intelligence cartographic analyst with the National Geospatial Intelligence Agency. I am also a pro se appellant, along with my wife Katrina Webster, in Fourth Circuit Court of Appeals case number 20-1488 and District Court case number 20-0009, Webster et al. Versus Lloyd Austin III et al. The case is really Webster et al. Versus the National Geospatial Intelligence Agency, better known as NGA, but the Secretary of Defense, Lloyd Austin III, is named in his official capacity because NGA is a Department of Defense agency. 12 days after my September 24th, 2021 video, the Fourth Circuit Court of Appeals rendered a decision in the Eastern District of Virginia's favor, essentially agreeing with the Eastern District Court's dismissal of my and my wife's case. The appeals court stated in their 10/6/2021 unpublished decision, and I quote, "We review the record and find no reversible error. Accordingly, we affirm for the reasons stated by the district court as to those claims preserved for appellate review. We dispense with oral argument because the facts and legal contentions presented are adequately presented in the materials before this court, and argument would not aid in the decisional process." The court went on to state that appellants' informal brief did not address their challenge that Katrina Webster's claim against the National Geospatial Intelligence Agency were an improper attempt at claim splitting. Thus, we declined to consider these claims. But the Fourth Circuit Court is clothed with the authority to issue a sua sponte decision, which means a decision of their own accord. It should not have taken the Fourth Circuit Court 18 months to come to their stated conclusion of a few lines. As I stated in my previous video, the Fourth Circuit Court has unfairly shielded this white federal agency lawyer by the name of Jack W. Rickert, and this time they shielded him from lying in his sworn declaration before the U.S. District Court for the District of Columbia. Background information. This case was initially filed at the U.S. District Court for the District of Columbia as case number 19-2231. The judge initially assigned was Christopher Cooper, a black judge who was appointed by President Barack Obama, but the case was transferred to the U.S. District Court for the Eastern District of Virginia in Alexandria, Virginia, at the United States Attorney's request, supposedly for jurisdictional reasons, and was reassigned to a white U.S. District Judge by the name of Thomas Selby Ellis, where the case number was changed to 20-0009. While the case was initially assigned to Judge Cooper of the District of Columbia District Court, the National Geospatial Intelligence Agency's Assistant General Counsel, Jack W. Rickert, was ordered by Judge Cooper to respond to this court complaint that was filed on 26 July 2019. Mr. Rickert lied in the October 8, 2019 sworn declaration at line number 9. He provided the following statement to the District of Columbia District Court and the U.S. Attorney Joshua Rogers, and I quote, "At no time was any hiring decision or EEO-related decision made with respect to any alleged job application or EEO complaint made by Ms. Katrina Webster." My wife responded by stating, and I quote, "Pro se plaintiff Katrina L. Webster is providing the attached document to prove that Mr. Rickert's sworn statement is in his declaration at ECF 8-1, which is electronic court file 8-1, was a lie when he stated, at no time was any hiring decision or EEO-related decision made with respect to any alleged job application or EEO complaint made by Mrs. Katrina Webster. I have also attached an appeal decision and right to sue letter from the EEOC Office of Federal Operation for PH 02E19. My case was dismissed by EEOC's Baltimore Field Office Supervisory Administrative Law Judge Samuel Tiedemann, even though the formal complaint was never investigated by NEMA, NGA's predecessor agency, since it was filed in March 11, 2002. I believe Administrative Judge Tiedemann worked under the supervision of Mr. James L. Lee when he was the director of the Baltimore field office, end quote. Still, after Mr. Rickert was caught lying in his sworn declaration, District Court Judge T.S. Ellis dismissed this case. Judge Ellis is a senior judge who has been on the bench for over 30 years and was allowing Mr. Rickert to get away with lying in his sworn statement. This Assistant General Counsel thinks he is above the law because these white judges have been allowing him to get away with lying under oath, and this time he lied because in this March 11, 2002 case that was illegally dismissed by EEOC Supervisory Judge Samuel Titleman, Rickert, along with NEMA's former acting EEO Director John Sikowski, along with Judge Charles Shubo, were named as responsible management officials. In fact, this complaint serves as documented proof that Mr. Rickert and Administrative Judge Samuel Titleman colluded to dismiss this case so that the Fourth Circuit Court could render a decision in the agency's favor in Fourth Circuit case number 04-1739 that was decided on December the 1st, 2005. The facts that were contained in PH 02E19 were sufficient to change the trajectory of the December 1st, 2005 decision. Administrative Judge Titleman was also the administrative judge who forced my lead attorney, Christopher Brown, to drop 103 of 107 claims of race-based discrimination and retaliation, and one of those dismissed claims stated that my wife's prior EEO activity had been leaked to her DOD Navy employer. My wife's case as Supervisory Administrative Law Judge Samuel Titleman illegally dismissed, PH 02E19, stated the following, and I quote, I, Katrina L. Webster, am filing a complaint of discrimination according to my race, Black Afro-American, and retaliation against me for my prior EEO activity, HQ 98E06. Issue, I believe the circumstances surrounding violation of my husband's most recent settlement is also an act of racial discrimination and retaliation against me for my prior EEO activity, HQ 98E06. Circumstances surrounding violation of my husband's settlement. Number 1, I was discriminated against by race and retaliated against for prior EEO activity by Jack Rickert and NEMA's General Counsel, John Sikowski, and the EEO office and NEMA's management in violation of settlement agreement when, number 2, NEMA's complaints manager, Mr. John Sikowski, and NEMA's Associate General Counsel, Mr. Jack Rickert, violated settlement agreement and breached promises set forth in October 1st, 2001 correspondence, on which case was dismissed. On 27 December 2001 at 2:12 p.m., Mr. John Sikowski, in an answering message, promised that I would be receiving a GS-14 promotion consistent with October 1st, 2001 correspondence settlement terms, which never was fulfilled as promised. I believe this EEO office is not neutral, but works with General Counsel to advantage the agency as evidenced by concerted effort put forth by NEMA's General Counsel and EEO office to breach settlement agreement. Number 3, I am filing a discrimination according to race and retaliation on the improper manner in which this EEO office processed and handled EEO complaint number 120-A as in Apple 1-4240X with regard to manner in which it was forwarded to Judge Shubo without the case being properly closed, and believe this was an act of discrimination that factored in why the agency violated settlement agreement. In retrospect, the intentions of this highly suspicious activity, which was to disadvantage me and favor the agency, looms large in respect to manner in which settlement agreement the agency and I entered into was breached. Number 4, discrimination according to race and retaliation due to improper manner in which my periodic reinvestigation has been conducted, end quote. Signed, Katrina L. Webster. The reason why Mr. Rickert lied to Judge Cooper and the District of Columbia District Court, stating at no time was any hiring decision or EEO related decision made with respect to any alleged job application or EEO complaint made by Ms. Katrina Webster, is because he was protecting himself. And secondly, because the complaint contained my wife's Department of Defense Navy employer's address, which was used to contact her employer and inform them of her prior EEO activity. And this has resulted in her being non-selected for every promotion she has applied for over her 23-plus year career. This lie that Mr. Rickert stated in his sworn declaration was deliberate and should be sufficient for an immediate default and default judgment in appellant's favor on all counts. The NGA director at Baraba Sharp should fire Mr. Rickert for lying in his sworn declaration and reverse any case in which Mr. Rickert has served as a representative. Not only should the lower court grant a default and default judgment in plaintiff's favor, pursuant to Federal Rule of Civil Procedure 55A and B, I'm also demanding that the December 1st, 2005 Fourth Circuit Court decision for Webster versus Runfield and James Clapper Jr., case number 04-1739, which was decided on December 1st, 2005, is reversed to a decision in plaintiff's favor, with retroactive damages from October 2001 to present, in light of the lies stated by Mr. Rickert in his October 8, 2020 sworn declaration at ECF 8-1. Thank you for listening to this message.